to investors. Well, this is the video that we've been working on how to show you how to self-close a subject to deal. Now, understand this is going to be the basics for you to be able to close any type of real estate transaction, no matter if it's going to be a subject to contract for deed, agreement for deed, the types of stuff that you need. First of all, you need to understand what the basics is. And I'm going to walk you through, kind of show you some of the basics and explain the basics, but it's going to be up to you to get that information from your local state authorities and also whatever based on your local information. So I'm just going to kind of run through, going to read here. You've already saw in a previous video the disclosures and so forth. If you're asking the question, should I get an attorney to close my deals? The answer is probably yes. Should I use a title company to close my deals? The answer is probably yes. But there will be a time and a place where you may choose to do this yourself, or you may feel like that you really want to kind of like flex your muscles, that kind of stuff. Even though that we may use a title company or an attorney to close our stuff, we still prepare our own documents, just like a bank does. See, the bank prepares their documents and send them to the lender. Send them to the title company or attorney to close. That's all the attorney is and title company. They are a facilitator of the paperwork. Do they prepare some documents? Yes. And as we kind of go through this, I'm going to kind of show you some things. Now, again, we are using a land trust to close our deal. This is buying a property subject to. This is an imaginary property with imaginary people. You may see my name in there and so forth. So I'm just going to jump right into this. You probably have already read this first paragraph, but I really want to spend a little bit of time here going through this. So it says here, when you make the decision to close a real estate deal yourself, you are accepting the responsibility of all your actions. And that's very important, because if you mess up, hey, look, you're the only person that can point the finger to it. Understand that you must use proper acknowledgments and jurats to use when you're completion of the documents. Now let's stop right there. In some states, whenever you use a notary, you must have the document properly acknowledged. So this could be on, say, for a warranty deed, or this could be a grant deed, depending on what state that you're in. It may have that you acknowledge who that person is. So when the grantor, who is usually the seller of the property, is signing the deed, the notary is acknowledging that this is John Smith, and they are notarizing to the fact that this is the true person. Now, in some states, they will have like a jurat. Well, a jurat is a sworn affidavit where the notary has to have the seller swear under oath that the statements that they're about to give is true. So they have proper language that you must be able to use in your state. Every state is going to be different. Every state's going to be different. They have different acknowledgments and they have different jurats. See, you may want to be able to use that title company, but you must be able to know this information. This is the basic information that you need to know when using a notary. Now, a notary may see your document and may see the acknowledgement, and they may acknowledge that, say, look, this is wrong. And by the way, they will change it, because they cannot acknowledge somebody under a proper improper acknowledgement or under an improper jurat. Those of you know that we are notaries, and we kind of little stickler there. So from a title standpoint of view, this is what we do. We call a title company or an attorney to order what's called an O&E, Owner's and Encumbrance Report. Now, an O&E is basically this. What they're going to do is they're going to go to the property, and they're going to say, okay, sellers owned this property since 2016. So they're going to go back and they're going to go ahead and look at the property and say, since 2016, what has John Smith been up to? So they're going to go right in the courthouse. They're going to do a name search, and they're going to say John Smith bought this house April 1st, 2016, and he got financing April 1st, 2016, and John Smith has been pretty clean ever since. So you'll get this thing here. They may call your utility department, and we'll get into that here in a few minutes on what we do on our end. And they may call other things within your city, within your state, that's customary, that will affect the title. And that's what we're looking at. We're looking at something, what can slander the title against John Smith? This could be a pending lawsuit. This could be something that would slander the title. Now, some of your documentation, whenever you're talking to the seller and they're going through some things, they're going to state some things that, you know what, I've got an open bankruptcy. These are things that you need to be worried about. These are things that you need to be worried about based on what you're trying to do in your business, because they can affect title. They can affect title. And you want to know this whenever you are talking to the seller. This is why you need to have an education on how title works. It's very important. But if you like what you do, so forth, if you like everything that owner coverage report says, and so forth, you can check it out. We always check title ourselves. See, we take the O&E that we get from the lender, that we get from the title company, and we read it. So we're looking for a trail. We're looking for, like, when John Smith bought the property, we may go back 2 or 3 sellers and find out if they got proper title insurance. If everything was done okay, because what I'm looking for is, I'm looking for holes. I'm looking for holes that may come back and bite me, and that's what I'm looking for. But we let them do their inspection, but we do our own during the same time. And we take and just like Smith, we follow that trail. We do the name search. We're looking for anything that could endanger the title. It'll be open for open lawsuits, liens from state and federal judgments, opens and closed. They could have gotten a divorce for a DUI and not paid their fine. Well, did you know that can put a lien against the property? And once you buy it, guess whose it is? It is yours. How about a divorce? Some states, you've got some dowry rights there, and they may not have been passed on. In the state of Florida, we have what's called homestead rights, and if they did not get a quitclaim deed from the spouse that left the property, this could also damage the property. Slander the title. We also check to see what type of utilities are. Are they public or private? If they're public, I'm calling to see if they have any bills. Any open water bill, sewer bill, power bill. I'm calling to see those, because those can attach to the property. I'm also looking for if there's any special assessments that may be coming along. They may be thinking, why special assessments? Well, they may be putting a water line in. They may be paving the street. And there may be an assessment that be coming along in the next tax period. I want to know that, because, again, I'm basing my decision to buy the property right now. Once they sign that deed over to me, and once I put money into the transaction, understand it is mine. I'm finding out if there's any HOAs. If it's in an HOA, I want to find out what is on it. We'll send them what's called an estoppel letter. We talked about that in the subject to workshop. And we also send an authorization release to the lender. We're getting that information, finding out what type of loan that they have, getting an idea if this is something that we really want to buy. Now, a lot of the stuff we're already going to know, because we've talked to the borrower. They've given us their information. Hopefully, they've given us their previous house papers. They've given us their insurance declaration, so we know how we're going to go ahead and pass on the insurance by canceling the policy and putting a new policy in check, put a new policy there when we're ready to close. Again, this is not about that. We are just going through the closing process. So I want to go ahead and jump right in some of the documents. Now, since we do take title into trust, what we're going to do is we're going to do what's called an appointment of land trustee. You must do an appointment. And this is a document where the trustee, the one that you pick, agrees to take title. So what we're going to do is we're going to go ahead and have the paperwork created, or you create it yourself, or have a paralegal create the paperwork. Paperwork's going to be created. And then what you're going to do is you're going to go ahead and appoint your trustee. So in this instance here, we're calling it the Smith Family Trust, and John Adams, whose address is that, any city, any state. And the seller, we're going to go ahead and type in the seller's name there, and the seller is going to sign it as 100% beneficiary. John Adams is going to sign there, and he's going to check the box that he's going to accept it. So right now, John Adams has agreed to be trustee of the Smith Family Trust. So now he's going to be trustee of the Smith Family Trust. He must agree to accept title, because you just can't put somebody in there. They must agree to it. The second thing is we call appointment of land trust successor trustee. If John Adams could not be our trustee, we have his wife, Mary Adams. And again, it's the same process. They must agree to step in as successor trustee if the first trustee does not have does not. Now we have the land trust agreement. Now here we're going to have the state of and county of. This is going to be where the document is created, not where the property is. It could be, but we're going to put it in here. It states this date, Smith Family Trust, John D. Adams as trustee, Emerald County, State, Florida. You know, you're going to go ahead and put in there. The legal description. Here is a secret that I want to teach you that will save you a ton of time and a lot of typographical errors. You already have a copy of the seller's warranty deed. What I want you to do is I want you to cut off the legal description. Put the legal description on a white piece of paper and copy it. Make several copies. Make several copies. Handwrite Exhibit A. Boom, attach it to the land trust agreement. Guess what you did? You just got the legal description attached right there. There's no typographical errors and so forth. Trust me, you leave a one off, you leave a semicolon off. I'm not saying that it will cause a problem, but hey, why take chances? That's just a little secret right there. Seller's going to go be the 100% beneficiary. If there was two, if it was like a husband and wife, we would have seller name and buyer. We would have both seller and both husband and wife there. As we're moving forward, Mary Adams is going to be successor trustee. If our trustee is not able to be there, we may elect to have Mary to step in his place. And you should already know what this document is if you've already been through the closing. And again, this is where we're signing. We're signing everything right here. Compensation, we pay $100 and $100 per year after the closing date. We're going to have a witness. We're going to have John Adams is going to sign it. He's our trustee, right? And this is where John Adams is going to say, hey, John, do you swear to be trustee of this property? John's going to say, yes. And a notary is going to go ahead and sign it and date it and sign it and date it right there. And guess what? Beneficiary is going to say, hey, Mr. Beneficiary, are you going to be beneficiary of this trust? And they're going to say yes. And notary's going to sign it. And you're going to have a witness. Now, do you need to have a witness? You know, it's up to you. Again, check your state, find out if you do. Belts and suspenders. I don't want any doubt at all. I always have somebody there with a notary and so forth. If you can't, leave it out. But I certainly would want to. If you plan to do a mobile closing, which you probably are, just tell the seller to have a friend of theirs, to have a friend at that location that can act as a witness. This is where you do the legal description. You remember when I said attach legal description here? Boom, right there. This is where you would paste it. You paste it on there and make a copy of this document. Make a copy there. That's all it is. You're just going to go ahead and paste it right there. Or, you know, I would just take this sheet of paper, paste it right there, and make a copy and put it inside here. This is the deed. Again, the deed that you use is going to be the deed based on what your state is. This is not, you do not have my permission to use this deed. All right. You need to use the deed that is used for your state. This is a warranty deed. You could have a grant deed. Where the document is created, Florida, state of, address returned to. Again, you're going to format that. Smith Family Trust is J.D. Adams as trustee. I use initials. Seller name, it's going to be the grantor. It's going to be the seller. If you want to use John Adams as trustee, you can do that too. Attached legal description as Exhibit B. Interesting. It's attachment. So you're not like typing in that legal description. Mortgage recorded deed book. What we're going to do here is we're telling the whole world that we're taking title to this property subject to. If that isn't disclosure, I don't know what is. Everybody knows now. Depending on what your state is, you know, you may need to have a notary acknowledgement, or you may need to have a jurat. You know, here in the state of Florida, we use a notary acknowledgement, so we would put our notary acknowledgement right there. I'm using it at the bottom, but right here is you can have two witnesses sign it. In the state of Florida, we're only required to have two witnesses, and a notary can be a witness. Some states you only need to have a notary. You need to know what the proper laws are for your state. Affidavit of trust. This is the document that gets recorded with the deed. All right. So you're going to have your deed, and then you're going to have the affidavit of trust. Because if not, when you decide to sell the property in the future, you have to record the trust. So what did I say? Use the affidavit of trust. Exhibit A. This is going to give the powers of the trustee. You remember that big old land trust agreement that we just used? The powers are right here. So Smith Family Trust dated when? It tells when the date of the creation of the trust. Who is trustee? John Adams. Legal description right there. Trust mailing address. You want to know how they can contact you. Trustee's powers and all that stuff tells you what the trustee can do. Won't go into details there. You can read that on your own. Guess what? If we can't have our trustee, Mary can come into play. That's Mary right there. Again, we don't have to record anything. We've got it already recorded in the deed as an affidavit of trust. This is where we have them sign again. Unofficial witness, if you want to. He's affiant swearing that he is trustee of this property and not a notary. So what we do is, this is where I have my notary stuff right here. It's down here at the bottom. If your state requires you to do it up there with the deed, do it there. I have done it both places and it's fine. Let's just keep going. This is going to be the legal description of the property that's attached. Remember, we have the land trust. I'm sorry, we have the warranty deed. This is legal description for the warranty deed. It is right there. Even says right there, warranty deed. All right, here's a couple letters that we have the seller to sign. This is a letter to the bank. We put this in our what? In our folder. You already know what this letter is. You've already seen it. Dear sirs, we're putting this property into we're putting our property into an account for estate planning purposes. And we're going to let Jonathan Rexford as agent, and I'll show that to you in a minute, what that looks like. This is me taking care of it. They're signing it. When all the information, we usually send this letter in. It doesn't do any good. They still want to know who is everything. This is the letter that we put in our thing, just in case if they rattle the cage and want to call the loan due. By the way, I've never sent this letter in. So, and if you are taking it into a personal property trust or into another entity, you may want to go ahead and have the interest recorded right there. I'll let you talk to your accountant about that. Seller's property disclosure statement. I have them fill this out while I'm at the contract. You may want to have them fill this out at closing. It's up to you, but I usually have them fill this out. I'm putting it here because a lot of people aren't doing this. They're not, sometimes you may want to have them fill it out twice so you can find out if they're telling a lie or not, So it's just a standard seller disclosure statement. And they sign seller's affidavit. This is where they are saying that they have a loan from that lender, and they are stating that there are no judgments, liens, bankruptcies, and that kind of stuff. They are swearing under oath that this is it. Remember, you've already checked. This is them swearing that they're doing it. All right, because you don't want to take anything public. I mean, anything subject to if they have any issues. Now, this is kind of like your CYA letter, all that good stuff. Ownership of the property, they're the owner. Acceptance, they reviewed all the interest. Good, valuable consideration. I'm having them initial all this. It's not a loan, especially if you're working with people that are in foreclosure. Copies of the paperwork. I understand that the copies of paperwork I've signed will be provided for me, which is very important. What we normally do is we print a signing package and a copy package. The notary that you're working with will know about that because they do quite a bit of it. I'm entitled to make a profit. Legal counsel advise. I'm not giving him any legal, financial, been fairly negotiated. They have no precluding ailments. They're not nuts, emotional. They're not under the influence of alcohol or anything like that. Not under duress. I'm acting on my own accord. Do not need advice from outside parties. You're getting all this stuff checked off. Checked off. Again, belts and suspenders. Belts and suspenders. Will this document keep you out of court? No, because they're going to sue you either way if they want to. They're going to go ahead and sue you. So, but I still get it signed and get it signed off because I want them in their mind knowing that this is a closing. This is it. We're spending time going through these documents. Trustee authorization. Smith Family Trust, John D. Adams says, as trustee, holds title where I hereby authorize a named trustee or such other trustees that succeed. Trustees signatory authorization on my behalf to endorse for the benefit of trust any hazard insurance premiums, claims, checks, blah, 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 blah. I also authorize a trustee of the named trust signatory authorization to modify any existing hazard insurance policy, so forth. This is the authorization of power of attorney. This is the limited POA there for the trustee. If you need it, again, belts and suspenders. We're already going to have our state power of attorney that's going to be given to somebody personally. But it is specifically for the property and the trustee. Because usually, whenever you cancel the insurance, who will they put the insurance name of? It's usually name of the seller. So instead of them getting the premium, why not have the premium sent to you so you can endorse it as trustee and put it in your trust account or put it into the account that you're needing. So if you're holding this into an LLC, you need to craft those documents that will pertain to your LLC. Seller's mortgage disclosure. What is this? This is the due on sale clause. Whereas seller and assigner beneficial interest, Smith Family Trust, which holds title to herein below, I've been made aware, understand the execution of the sale, granting the beneficial interest in the above named trust may contrary to the terms and conditions of the security deed or mortgage assumed by me in favor of existing mortgage holders, secured by below. Blah, 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 due on sale. I also understand that the purchaser is taking beneficial interest in the trust that holds title property subject to existing mortgages, thus not releasing me from the liability of the mortgage holder for repayment of existing mortgages. I understand the assignee of the beneficial interest intends to bring my loans current if necessary and make monthly payments. However, no obligation to do so. I'm going to tell you, if you're taking a property subject to and you told them that you will, you better damn well make those payments, or else I will hunt you down. This is the assignment. This is where they're transferring the interest of that trust that was created on their behalf. They've created a trust for estate planning purposes. Now they are selling that interest over to you. This is them. Smith Family Trust, date of the trust creation date, 100% beneficiary. They assign and quit claim. Seller name, witness, notary, your trustee signs. Don't record this document. Management. This is where the trustee of the Smith Family Trust hires me as manager. I'm just a manager. Again, who am I? I don't own this thing. I am just the manager. Management agreement. And then I sign it and everything's hunky-dory. This goes into your folder, all right, for you to do it. Now, next document that I'm about to get into is a settlement statement, okay? I'm not here to teach you how to fill out a HUD-1. It is math. You've got debits, you've got credits and debits, whatever side of the play that it gets on. You have negotiated your deal. So you should know what your agreement is to give the seller. You should know what the agreement is to make up payments. I'm not here to fill in all the little blanks. Understand we can make an entire workshop out of this. Just going to show you one that you can get offline. Go to HUD.gov and you can download a settlement statement. But this is one here, made up Ajax closing. So name of the borrower, that's you. Name of the seller is the seller. Name of the lender, subject to. Settlement agent could be you. date of settlement. Contract price. This is the price that, what I normally do is I fill out contract price first. So I do buyer and seller side. Now I'm going to go straight to page 2 of this agreement. Those of you that are in the title business understand that's where the money is. If you were to pay a real estate commission, you would put what the percentage is here. And if it's going to be deducted from from the seller's proceeds, you would put it there. Or if it's deducted from the buyer's proceeds, you would put it there. Required to pay interest. If there's any prepayments, you may pay it up front. If there's any prepayments that you have to pay, such as if you need to bring payments current, you can stick it right here to be paid in advance, or you can go all the way down here to bottom and pay it outside of closing. This is where additional settlement charges and stuff like that you can add. This is normally where people put their assignment fee, if there is one. All right. Now with this one here, we just added some things in here. We've had some prepaid interest. Kind of see the date back to 2015 on this one, on this old one here. I didn't change the date on it, but this is recording fees for the deed. Do you pay recording fees for the deed? $6, $7? Where do you find that out? You get on the phone and you call your county courthouse and find out, hey, how much does it cost to record a deed? And you put it right there. Deed stamps. How much is your transfer tax? You put that right there. Are you making any prepayment on taxes? You know, what type of taxes do you have? Are you paying for title? Are any title insurance? Not title insurance, but did you do an O&E? Are you taking some things that you want to document the expenses on this property? Because again, this is for tax purposes too. What were your settlement fees and so forth? What type of insurance did you have to pay? Annual assessments. You go ahead and put all these in here. Now, as we're going down, you're going to see these two charges, $7,000 and $6,000. The $6,000 right here is in result of paying the 3%. Now let's go up to page 2. Now, page 2 of this agreement, we said 200 is a contract. 729, again, settlement charges from my buyer's side or my side is brought over to the front page. County taxes. Usually seller pays the day of closing. So whatever payment that you need to bring in, it's going to count as a debit to the seller, credit to the buyer if you pay taxes in arrears, and debit to the seller. So now this is going to show as a credit to you, but it is a debit to the seller, whatever the taxes are. So as we go down, so that's why it says their total cost due to seller is $206,000. There, right there is your $6,000. All right, now you're taking loans existing subject to of $190,000. 190, 203, 190, 503. And as you're going down, paid on behalf of borrowers 190, 196. Total due from seller 200,000, 201 minus the 190. So you get what? 11,405. So you're bringing $11,405 to the closing. Now, right here is it's going to be deducted from on the seller side. So right here we have a gross amount from $200,676 minus $196,000. It's going to be the $190 subject to plus $6,000. That means that the seller is going to get $4,676. So that means that you're going to, if you've done all your math and this deal is done right, you're going to give a cashier's check or you're going to do a wire to the seller for $4,676. Now this could be zero. This could be the seller pay you. Again, math is math. So that is it on the grand scheme of things. So what's going to happen is you're going to sign, seller's going to sign, and if you want to have a settlement statement, so this is kind of like an internal document. This is like where is the math? Follow the money. You're going to follow the money on this situation. So that's it from kind of like beginning to end. There's a lot of little nuances that go in based on your geographic location, and you should be able to kind of follow through. Now, nothing that I've said should prevent you from being able to do this yourself, or you should be able to use this information and follow along with your professional that you're using to close your real estate deals. I'm strongly encouraging you to do that, because, and do not take this video, like I said in the other one, do not take this video and say, oh, I'm going to go close my deal. Use this to expand your knowledge on be able to do it. We close transactions every single week ourselves. Find a mobile notary that will maybe walk you through one, that kind of stuff that does loans. Go to 123notary.com and you'll find a notary in your state that might be able to help you out. And that's it, gals and guys. So enjoy the video, and hope this has been beneficial to you. And if not, well, can't help you any other way. All right, take care. Lord willing, see you again another day. Bye-bye.